Okay, now, in a minute, our distinguished speaker, Professor Philippe Sands, will talk about arguments for indigenous peoples in the case of Colombia versus Ecuador.
Great. Well, it's great to be here, and there is not enough cross-fertilization between our different faculties at UCL, so I am very, very pleased to have been invited even at 10 o'clock on a Sunday morning.
After being in the States for a week.
I come back yesterday from the United States for 2 weeks, and so I'm pretty out of it, but I am going to do my best first thing in the morning. So I thought what I wanted to talk about was something that is not in the public domain, and it was the experience that I had in a case that was argued at the International Court of Justice. I wear two hats. I'm a professor here at UCL in the law faculty, and I'm a barrister at Matrix Chambers, so I litigate cases, but only international cases, and almost only in international courts and tribunals. One of those courts and tribunals is the International Court of Justice. I think I've got this one, actually. So, is the International Court of Justice in The Hague, sometimes known as the World Court, which is the principal judicial organ of the United Nations. 15 judges. And they hear a whole raft of cases. One of the cases in which I was involved, I became involved in 2009, was the case brought by Ecuador against Colombia. Colombia had for many years been engaged in the spraying, the aerial spraying of coca crops, plants for the production of cocaine, in Colombia and on the border between Colombia and Ecuador. And for many years, Ecuador invited Colombia to cease and desist from spraying in border areas because, on Ecuador's argument, the pesticides were crossing the border into the territory of Ecuador. One of the basic principles of international law, drawn from the idea of sovereignty, is that a state cannot do something in its own territory which has consequences in the neighboring territory. And so Ecuador, after years of unsuccessful efforts at persuading Colombia to create effectively a buffer zone so that it would not, you probably sound as though you may know the story quite well from a Colombian perspective, decided to bring international proceedings and retained a law firm in Washington, D.C., the law firm of Foley, Hoag, and Elliott, and in particular a colleague and a very good friend of mine called Paul Reichler. Paul Reichler, very well known for having brought the case for Nicaragua against the United States in 1983. So well known in South and Central America. The case was brought on the basis of the Pact of Bogota, which allowed for two states in dispute to resolve their dispute before the International Court of Justice. In running the case, counsel had a range of different ways of arguing the case. At the heart of any such case is the issue of evidence. What exactly is Colombia doing? What are the consequences of what Colombia is doing? And how do you prove what Colombia is doing? This is an area which is not heavily populated, but which is populated by three Afro-Ecuadorian indigenous communities, the Awa, the Kofan, and the Kishwa. And the government encouraged us to work very closely with those communities in seeking to gather the evidence as to what had happened. I have to say, at a personal level, that was a completely fascinating experience. I'd had some experience of working on oil issues in other parts of South America, but this was the most intense experience of gathering witness statements from communities who are obviously not used to preparing the kinds of witness statements with the degree of precision. What happened? What day did it happen? What were the consequences? The kinds of things that Western international lawyers want are not the kinds of things that those communities in that particular location and time would do with the degree of precision that we want. That was a very interesting experience. We can talk about it more in terms of the question and the conversation. So that was just a simple practical issue that arose. An extensive time was spent working with the community, working not only with words but also actually with images. What did the planes that were coming over look like? How do we know they crossed into the territory of Ecuador when that was denied by Colombia? There's obviously no photographic evidence, there's no video evidence. You're reliant upon essentially observations by human beings and the consequences on the ground of the spraying of the pesticide, which has a very limited lifespan. So it basically kills all plant life that it touches, but the plant life then regenerates and regrows, and it does not leave a trace beyond a period of several months. So when you're bringing a case, as occurred here, that is several years after the event, because temporarily Colombia suspended the aerial spraying, you face a very real evidentiary difficulty in proving what happened, which meant that the witness statements of the individuals from these communities became absolutely crucial in proving the case. How to run such a case? In law, and I apologize for giving a brief lesson in international law to put it in context, you can run such a case in a number of ways. Firstly, you could argue that, and I'm not going to be exhaustive here, that Colombia has violated the sovereignty of Ecuador simply by the intrusion of a pesticide onto its territory that violated a principle of sovereignty. Secondly, you could run it as an environmental case, that the introduction of a harmful pesticide caused environmental harm on the territory of Ecuador. Thirdly, you could run it as a violation of fundamental human rights case, namely that the human rights of inhabitants of the area which was sprayed in Ecuador had been violated. And fourthly, you could run it as a violation of the rights of indigenous communities, and that's what I want to talk about today. So you've got four different possible heads of argument, and the lawyers in the room and the Supreme Court judges from New York in the room will understand the difficulties of strategically, when you're running a case, how do you decide which, if any, of the different causes of action, as they're called, do you run with? In the end, Ecuador ran with all four. Okay, they were distinct, each stood on its own, they were interrelated, but they were separate. And we decided to run on all four, in large part because this was a first case for the International Court of Justice. They'd never had a case quite like this. And so we just didn't know how the judges would react to different types of arguments. They'd had cases on sovereignty, they'd had cases on human rights, they'd had cases on environment, they'd never had a case on indigenous people's rights. There is no case of the International Court of Justice which passes judgment on ILO Convention 169, which I was charged with drafting the arguments for, which was a really fascinating experience. The International Court of Justice is a very conservative court. They don't like new types of arguments. And interestingly, in the preparation of the arguments, it has to be said that there was some difficulty in persuading the entirety of the team to run with indigenous people's arguments, because it had never been done before. You tend to go, and I'm sure it's the same in the state of New York, if you've got an argument that's been run before in which there's precedent, that's what you go with. When you're in the domain of new arguments, you're already in some degree of difficulty. On the other hand, we knew that there were some judges on the court who would be very open to arguments about indigenous people's rights and indigenous populations' rights. And I, and one of my colleagues in particular, felt very strongly that we should make these arguments. They intercepted and interrelated to the other arguments, but they were distinct. Now, one thing that I should say is that the arguments were pleaded, that's the written arguments, over the course of 4 years, from 2010 to 2013, and the oral arguments were due to be held over a period of 6 weeks with witnesses, including 3 witnesses from the indigenous communities on behalf of Ecuador in October 2013. But 2 weeks before the oral hearings began, the case settled. Basically, Colombia gave Ecuador everything it asked for and more. It's not fully in the public domain as to what happened in that particular settlement. There are some statements that are available, and you can work out from those what is going on. The upshot of the case having settled is that the pleadings are not publicly available. The rule at the International Court of Justice is that pleadings become available at the moment that the oral arguments open, because the oral arguments are held in open court. So on that Monday in October, simultaneous with the opening of the hearings, the President would have said, and now declaring the hearings open, you will find on the website of the International Court of Justice all of the pleadings in the case, which are extensive on these issues. And one of the things I will do now informally is just very briefly tell you about those arguments, then we can throw it open to conversation. But I am just thinking, and I was thinking yesterday in preparation for today, that there really is some fantastic research to be done on how the arguments were made, and in particular how Colombia responded to the arguments on indigenous people's rights. And I'll say a little bit about that. So I will undertake to explore how, if at all, for academic purposes, this material could be made available. But in principle, Ecuador could not make available the pleadings of Colombia because they're not the property of Ecuador, they're the property of Colombia. And for reasons that will become blindingly obvious to anyone who sees the pleadings, let us say that the arguments of Colombia were not entirely consistent with the approach taken by its own constitutional court in relation to the rights of indigenous people. So I can understand that Colombia would not wish these pleadings to be made publicly available. On the other hand, Ecuador's pleadings are its property, it can make its pleadings available, and from the second round of pleadings, the way an international court case is argued, the claimant state, Ecuador, puts in a memorial, then the respondent state, Colombia, puts in a counter-memorial, then the claimant state puts in a second round a reply, and Colombia then puts in a rejoinder, and then there are oral arguments. The reply of Ecuador obviously summarizes the arguments of Colombia, and from that you can work out what the arguments of Colombia are. But as far as I'm aware, to this point, these documents are not yet publicly available. So within the sort of context of the Chatham House rule, I'm going to just summarize very, very briefly. Chapter 9 of the memorial set out Ecuador's arguments, and it's entitled "Colombia has violated the rights of indigenous peoples in Ecuador." And the drafting of a title itself is significant, and that would have been very significantly debated. Has Colombia violated the rights of Ecuador, or has Colombia violated the rights of indigenous peoples in Ecuador? I was very concerned to say that it was the rights of the indigenous people that had been violated, and that by violating the rights of those peoples, the rights of Ecuador had been violated, rather than just violating the rights of Ecuador. And that was significant as a way of demonstrating, coming back to the point that you made, that the indigenous peoples of Ecuador have standing in international law. They exist as the holders of legal rights in their own right, not merely as citizens of Ecuador.
Interesting.
So what you will often find, for the lawyers amongst you, you will be keenly aware that words really matter, and the way in which you formulate a claim is reflective of underlying assumptions and beliefs as to who are the holders of rights. So that is significant. And what you'll find in the pleading is that it's a traverse through years of activity at the United Nations on the rights of indigenous peoples, all summarized. And the reason that has to go in, not because it's a basis for a cause of action, but you've got 15 judges at the International Court of Justice, the great majority of whom have no idea what this is about. And so part of the process of writing a pleading is an educative process. You're telling a story, and you're explaining to the judges that the arguments you're making today in 2013 may be new, but they have a history going back decades, and you need to set out that history in order to be able to explain to the judges that there is a long history in relation to these matters. And there was particular reference to the UN Declaration of 2007, which many of you will be familiar with, on the rights of indigenous peoples, and an articulation that the rights of indigenous peoples are also recognized in human rights law, and much citation of the case law of the Inter-American Court of Human Rights, which many of you in this room, I'm sure, are very, very familiar with. So the basic arguments in relation to the protection of indigenous peoples' rights were fourfold. First, the right to cultural identity, as guaranteed by Article 27 of the International Covenant on Civil and Political Rights, which of course goes back to 1966. And the argument was that cultural identity was undermined by the spraying of pesticides because it interfered with the ability of this particular community to make use of the land and the plants and so on and so forth. And cultural identity was obviously deeply connected to the land and the use to which the land could be put. Secondly, the violation of a number of specified rights in the 1989 International Labour Organization Convention number 169 concerning indigenous and tribal peoples in independent countries, to give it its full title. Third, the right of these peoples to property, as guaranteed by Article 21 of the Inter-American Convention on Human Rights. And fourth, violation of the constitutional rights, both in the Constitution of Ecuador and of Colombia, of the rights of indigenous people. So that was the four foundations of the case as it was articulated. I don't have time to go through each one right now, but I would simply say in relation to the first, Article 27, we had the benefit of really good jurisprudence, really good case law from the Inter-American, from the Human Rights Committee of the United Nations in a couple of cases brought under Article 27, Lovelace versus Canada and Lubicon Lake Band versus Canada, which concerned the application to allow private companies to exploit natural resources on the band's territory. So we were not in new ground, if you like, in relation to the Article 27 claim. There was also a report by UN Special Rapporteur which dealt explicitly with the question of the use of pesticides, more on the Colombian side, but also to a certain extent on the Ecuadorian side. And the report was very helpful to us on a factual basis because it indicated with considerable clarity that the aerial spraying of toxic herbicides had caused certain communities on the border area to abandon areas where they had previously lived, hunted, and fished. And a leader of the Confederation of Indigenous Nationalities of Ecuador, Mrs. Maria Blanca Chancosa Sanchez, gave a clear statement as to how the use of aerial spraying had interfered with traditional activity and undermined cultural identity. And she explained, and this was really for the judges, you've got to remember you've got a pretty skeptical group of judges sitting on this court for whom this is all totally new material. For the indigenous people, the bond with Mother Earth prevails in their lives. The land, the river, the natural forests are their sacred places where they can be in contact with the plants. Their relationship with the land, animals, and the environment of their territory is part of their being. Having to abandon their land is like killing a part of the indigenous person. He loses his center. That was a witness statement that was put in before the court, and that was going to be relied upon by a live witness appearing before the court, being examined and cross-examined. That was the Article 27 argument. In relation to ILO Convention number 169, there's a huge amount that I could say about it. It is a completely fascinating convention. It was really the first time I'd engaged very fully with that convention. But the provisions that were invoked by Ecuador, and I have to say Ecuador needed no persuading by its outside counsel to make these arguments. They were fully committed to the making of these arguments and to very far-reaching arguments in relation to ILO Convention number 169. And the violations invoked were Article 3, prohibition on discrimination, Article 4, safeguarding of persons, cultures, and environment, and Article 5, respecting the integrity of values, practices, and institutions of indigenous peoples. And then Article 13 became very central in the case. Governments shall respect the special importance for the cultures and spiritual values of the peoples concerned of their relationship with the lands or territories which they occupy or otherwise use, and in particular the collective aspects of this relationship. And then Article 7, paragraph 4, governments must take measures in cooperation with the peoples concerned to protect and preserve the environment of the territories they inhabit. And we use that provision to argue there had been a failure to carry out a proper assessment of the impact of the use of these pesticides on those areas, and there had been a failure to consult with the peoples directly. There had been no consultation at all with these peoples. And then finally, Article 15 of the ILO Convention, which provides, as many of you know, the rights of the peoples concerned to the natural resources pertaining to their lands shall be specifically safeguarded. These rights include the rights of these people to participate in the use, management, and conservation of these resources. And relatedly, Article 16, the peoples concerned shall not be removed from the lands which they occupy. So all of these provisions, for the first time, made it explicitly and centrally into a case before the World Court. And it was, we were sort of excited making the arguments, and we were very much looking forward to making the arguments in court. On the other hand, since Colombia adopted a buffer zone which stops all this aerial spraying from entering into the territory of Ecuador, it can be said that all of these rights are safeguarded by the settlement which was achieved. And as a lawyer, you obviously put aside your own desire to stand up in front of wonderful judges and make your arguments, and when you've offered a good deal, you take it. And frankly, the settlement went further than I think what the court may have given. And our advice was absolutely clear: take this deal. We cannot tell you you have a better prospect. You will get more from a judgment of a very conservative court. I'd also mention Article 29 of the UN Declaration, the right not to be removed from your lands. Finally, the third head of argument was the human rights argument. More may be said about that later. And the fourth head of argument was the constitutional argument. What did Colombia say in response to that? They made four arguments in response. First, and this was an argument that went all the way through in relation to sovereignty, human rights, environmental protection, and indigenous peoples' rights, there was no evidence of harm. Ecuador had not established that harm had occurred. That gets you into a very complex, almost quasi-philosophical discussion on whether you have to prove harm or the risk of harm. Frankly, 7 or 8 years after the event, it was very difficult to prove harm. We could show a few animals that had been killed. We could show perhaps some territory that could not be used for farming for a limited period of time. We could show some people getting sick, and we could show children being fearful. But we were in all cases reliant upon evidence that was limited in terms of the quality of the witness statements, because there was a degree of contradiction and lack of clarity in terms of what had happened, when it had happened, what the consequences of it having happened were. So we shifted the case much more to the risk of harm, which is easier to establish, which shifts the case onto the inherent, the content of the herbicide, toxic herbicide, basically showing that these are toxic herbicides that are banned from use in the United States and in the European Union, and banned in any circumstances from being used by aerial spraying. And inherent in that prohibition, we said, it was a recognition that this material was inherently harmful and should not be being used. So the battle lines were drawn in terms of evidence as to harm or risk of harm. The second argument made by Colombia was that it had not targeted the indigenous peoples. In other words, that the provisions that we relied upon, in particular in Convention 169, were intended to prevent a state from explicitly engaging in activity that explicitly targeted these communities. And incidental harm to the community by activity which is intended to achieve another purpose was simply outside of the convention. My own view is that Colombia was wrong on that argument and was not going to prevail on that argument, but that was the argument they made. It may have been made more for a domestic population, domestic audience. I don't think it would have succeeded, but that was the argument that they made. The third argument that they made, which is more complex and probably had stronger legs, was that the 1989 Convention 169 only applies to a state in relation to its own territory. So that the obligations under the convention did not have what are called extraterritorial consequences. Colombia could only be held to be bound by an obligation to protect its own indigenous peoples. The spraying that went across a boundary was not something that fell within the four corners of the 1989 convention. Again, I don't think that argument was likely to prevail. A similar argument had been made a few years earlier in relation to human rights norms in a case brought on an advisory opinion on the legality of the wall constructed by Israel to divide Israeli and Palestinian territories, and the International Court of Justice ruled very explicitly that various provisions of human rights law did apply extraterritorially, and I think the court would have followed that particular argument. And then fourthly, they argued that in any event, the populations in Ecuador had been fully consulted and the effects had been fully assessed. The case was delicate. Again, I don't think that was a very compelling argument. The case was delicate, shall we say, because the funding for this activity came from the United States, it was part of a program, some of you know, to stop the production of drugs which would make their way to the United States. So there were, in parallel, cases going on in US courts raising very, very similar issues to those that were being addressed at the international level. And my suspicion, but I don't have any evidence for it, is that the United States would have wanted to encourage Colombia to settle this case, because the airing of such matters, including the material that had made its way into the public domain through cases in the United States involving the companies that had been involved in an international forum, would have probably been unhelpful to the United States. So let me stop there and let's throw it open, because I'm interested to know what your reaction is to this material. The upshot of it is the arguments were made, the arguments were successful, but none of this is in the public domain because the case ultimately settled. Over to you.
Philippe, that is an absolutely brilliant way to kick this off, and it opens so many really interesting doors. I'd like to take the privilege of the chair just to ask two quick questions, and we needn't answer them, but they are really urgent in my view. One is the question of when it might be possible to get these arguments into a court decision so they can be cited as precedents. Because I think that the area that you're entering is so critical for Indigenous peoples that the need to be able openly to take the next step is, I think, very urgent. And along the same lines, do you have a feeling of in what context, or rather, let me rephrase this, what kind of problem might the argument make its most powerful or have its most powerful effect? I mean, obviously this came because there was pesticide drift, but the question of whether it might be an oil spill, illegal logging, water pollution, in other words, having gone through this process and seen what the law says about those Indigenous rights, are there potentially, if we were to select a problem, are there higher order problems at which you could actually get the kind of impact that would make those precedents even stronger?
Sure. I mean, on the first question, I'm not sure that you need a court judgment from such a court. It would be helpful. I think what is, I mean, the central point about all of this is that the fact that these arguments were made and were responded to, made by Ecuador, responded to by Colombia, underpins the centrality and the legitimacy of the arguments. In other words, they have heft because they were made before a distinguished court. And I would say that what's important is not only to get a judgment, but even before that, to get the fact that these arguments were made out into the public domain so that it can be seen that these arguments have legal leverage.
So they're accepted as arguments.
Yeah. And if you meld the arguments with what the terms of the settlement were, it's pretty hard to escape the conclusion that these arguments, along with the three other sets of arguments on human rights, environment, and sovereignty, were really central in forcing that solution. I mean, there was a skepticism amongst some of the lawyers that we should be making these arguments at all at the outset. By the end of it, once we'd seen Colombia's arguments, we were pretty comfortable that these were really rather strong arguments, and we thought that actually, on balance, the court would say something positive about these matters. So, yes, it would be great to have a court judgment affirming the value, importance, and consequence of these norms, but I think it's actually equally valuable to know that they were made, that they were responded to, and they had a consequence in the settlement. In terms of your second question, what areas might they be used in? It's hard to think of a more compelling area than the aerial spraying of a toxic herbicide. I mean, this was a pretty nasty stuff that was being sprayed over hundreds of thousands of square kilometres. I mean, this is not, just minor little sprayings going on, but you had hourly, sometimes daily flights coming along the border. And what was I found very compelling were the accounts given by younger people, children in particular, of the fear that they had of these planes flying. They claimed they could see these planes, and they claimed they could see material being deposited from these planes. Now, Colombia said that's impossible. You can't see it. It's invisible. They just fly over. You can't see it. But that was an evidentiary battle that would have to be resolved. But for a community that is observing this material, that is pretty powerful. And in fact, it is the absence of knowledge as to what is coming out of those planes that engenders very great fear. I mean, the same thing over here. If planes were flying around spraying stuff all over, we'd be asking ourselves, what on earth is going on?
I have maybe a witness. I live about 100 feet from an orchard that was sprayed by aerial planes, and these treetop flyers come over, and they blow your windows off at 5 a.m. when there's dew on the ground. So you leap out of bed.
Yeah. So this was a pretty powerful area, but I would have thought, oil spills, I've been a bit involved in ironically, the cases in Ecuador, also involving Chevron and that kind of material, so Ecuador's on the other side as well.
Julie?
Yeah, I've got a question. As great it is that they now stop spraying there, but was there any offer of remedy for all those years of fear?
Yes, there was. We were amazed. They offered a cash payment,
Okay.
which we thought there was no way the International Court of Justice would award money damages. I'm sorry, I can't remember exactly what the amount was, but it was not insignificant. And you can be assured that the lawyers for Ecuador also make sure this money goes to those communities and does not go somewhere else. So there is an implementation issue. I mean, these are extraordinarily impecunious communities. I mean, we went there, and I mean, some of you in this room have spent a lot of time working with these communities. You will know what it's like. But I mean, the level of poverty is staggering beyond belief. And these are, in that context, pretty large sums of money in terms of health clinics and in terms of, you know, dealing with the trauma as it was for younger kids. There was one of the most powerful things for me was the pictures that were drawn by children. And I think these are very much in the public domain. You can see them. But yes, there was not only we will stop, but we will create a buffer zone and we will make a payment in recognition of harm done.
So we have a question here, then Juan Pablo, and then in the back, and then several others. But let's take them one at a time.
Just one clarification. Ecuador hasn't chosen of its own volition to put its pleadings in the public domain.
As far as I know, what I'm going to do is I'm going to email Paul and just find out what exactly is the status of the pleadings, because I really do think, just talking now, I realise they really ought to be in the public domain. And there is a great PhD to be done on the way in which the case was argued on Indigenous people. One person could just really have a field day just getting into all of this material. So I think the position is it is Ecuador's property, its pleadings. It has the right to put them in the public domain, but it may have been a term of the settlement that it would not do so.
Thank you. I have a comment and a question. First, a comment. I was following the case because the people I work amongst in Peru, they live in Coca Island, and they're getting sprayed. And, well, they have no one to represent them, but we're trying to see what was going to happen after that, to see if then it could be applied to the case of them suing the Peruvian state for it.
So were they encouraged by what happened? I mean, it has stopped on the borders.
Yes, but now they have a bigger problem with the hydroelectric dam, so they kind of like move
Right.
their interest. Now, I'm going to be talking about this later when I talk about kind of like consultation law and how it's being worked in Peru. But my question is about what have Indigenous Amazonians in Colombia done with this information? With kind of like what happened? Kind of like the Colombian state accepting, okay, we screwed up, we're doing something that's not completely right. Have they been able to use that as part of a...
This was a really delicate issue, and we had a lot of contact with Colombian indigenous communities who were very supportive, but were very fearful of their own government. And it's treason. You know, you're helping another country. So this was extraordinarily sensitive. I think, I can't remember off the top of my head, but I think we did get two witnesses, two individuals from indigenous communities in Colombia were willing to have witness statements put in on behalf of Ecuador, which is a supreme act of bravery, which may be one of the reasons why none of this will become public, because I think in Colombia, but also in Ecuador, I mean, if Ecuadorian individuals had done this vis-a-vis Colombia, you would also expose yourself to life-threatening risks. I mean, you know, so we were very, very concerned about the protection of individuals, and some of the witness statements went in anonymized, and I think that they included Colombian witness statements, and we were in consultations with the court about how to protect the identity of particular individuals.
But can I just a quick follow-up?
Please, yeah.
But have their federations, have their political organizations taken their own case against their own state?
Oh, yes. There's a lot of litigation in Colombia before the Colombian Constitutional Court and Supreme Court in terms of the illegality of aerial pesticide spraying. And I suspect that one of the reasons Colombia settled was they saw the way the wind was blowing, so to speak, in relation to the international case, and that would undermine their domestic cases. Look, I'm not an expert on Colombian law, but what my Colombian friends tell me is the courts are not entirely independent of the executive, and they were subjected to intense pressure. We had a Colombian expert on environmental assessment law of Colombia testify on behalf of Colombia. She lives in Switzerland and teaches in the University of Zurich, and so she felt free to do that. But even she was very anxious about testifying as she did against her own government. It's a very delicate thing to do. So these are very sensitive matters, and it raises the very interesting question. I mean, the communities don't respect national boundaries. They straddle these national boundaries. So basically, whether you're Ecuadorian or Colombian, from their perspective, is neither here nor there. They're just a member of this community, and whether they happen to have an Ecuadorian passport or a Colombian passport, they couldn't care less. But, assuming they have one, or a right to have one. But in international law, you have the nationality, there's a boundary, and if you're on this side, you're Ecuadorian, if you're on that side, you're Colombian, and that will determine whether you're a traitor or not. So it's complex, it's really complex.
We have a question in the back. Someone had yeah.
Yesterday we were hearing about the survivors of torture claiming asylum in the UK and the incredible sort of burden of evidence placed on them to prove that they've actually been tortured, including sort of proving that they haven't inflicted scars on themselves and that they haven't got a third party to inflict wounds on them. I was just wondering, do you think that the evidence given by these people would have been taken as seriously if you didn't have the weight of America kind of pushing the courts?
I think it would have been taken seriously. I mean, I thought they were very credible, and they were very understated statements. As a lawyer, you assess the credibility of a witness, and you form a view as to whether or not that material should go in or not. They're going to be subject to cross-examination, although it's limited cross-examination in the international court. So you have to ask yourself the question, would they withstand a proper, decent cross-examination? And in the end, we only put in material where we thought that they would, although the idea of subjecting an individual from such a community to cross-examination is itself replete with cultural complexities. And we would have, in the hearings, we were preparing to spend quite a lot of time explaining to the court the cultural circumstances in which these kinds of issues arose. But the default position is the one that you describe, one of skepticism. And I have to say, this is very much in my mind. I've been reviewing for the past week for a book review for the Financial Times, a marvelous book which is coming out next week by a Swedish journalist called Goran Rosenberg, who describes his father's treatment, a guy who turned up in Sweden in 1946. It's called A Brief Halt After Auschwitz. The guy has spent 4 years in Auschwitz, and after 5 years in Sweden, he can't work anymore because he's been traumatized, and he puts in all sorts of witness statements, and the Swedish medical authorities say he's making it all up, and after 5 years he should be completely fine. So that skepticism that communities have about the credibility of these kinds of testimonies given is something that we all have to deal with. We know judges are skeptical, and maybe not all.
I thought that's required.
It's part of the job description to be a skeptic. So I think there would have been skepticism. There would have been some pretty hard-nosed lawyers on the International Court of Justice saying, yeah, just making it up, and you have to work hard to address that issue.
Rodrigo.
So you mentioned that it would be good to make these arguments public. Based on your experience, what's the best way to make them public so that the people can use them for future?
Yeah. Well, I certainly intend now to. I haven't done it. I mean, I realised it was a year ago, and I should have done it. I'm going to certainly ask the Ecuadorian government whether I can make them public for academic purposes. They will probably say they can't make the Colombian materials public, which means that you ought to be trying to get this material publicly available in Colombia in order to see the arguments that were made. They're not nice arguments. The arguments that I mean, this is the unhappiness of the Colombian situation. They're really minimizing the indigenous people's arguments. They're really saying basically this is bullshit and you should not be running this. They use the word absurd, actually. And I remember when I saw that, I thought, wow, that's a bit strong. I mean, that should not be being said about arguments of this kind by a country like Colombia. So I suspect they will have an interest in not making this material public.
But when it's made public, because I know nothing about how is it made public? Is it a report? For us as scientists, we publish a peer-reviewed article or a note.
Well, the ideal would be for simply the full pleadings to be made publicly available, on a government website in Ecuador. But I'll have to check. I'm going to check there now. It'll take time to get the answers, but I'm now going to check as to whether it was a term of the settlement that none of this be made public, in which case you can't get any of this material. And this brings me into the frustration of being both an academic and a practitioner, is you come across material that you really want to write about, but you can't write about it. And there's a conflict between being a practitioner and an academic.
Isn't there deadlines for this kind of agreements where it has to be kept private?
No, it can be indefinite. It can be forever. If the settlement agreement was the pleadings should not be made public, that is the end of the matter. But I wasn't involved in the settlement negotiations, so I don't recall what was agreed. But if there is something in the agreement, then it will not be made public. If there was nothing in the agreement, then it swings to persuading the Ecuadorian authorities to make some or all publicly available. I think they can't make available the Colombian ones. My advice to them would be you can't make available the Colombian ones. It's not yours to make available. But what are the reasons against making their own arguments available? It's hard to see, absent an undertaking, why they couldn't make them available.
Now, we are actually over time, so I'm going to take one more question. Obviously, we'll revisit this repeatedly. Okay, we'll take two together. Just state your questions and allow Philippe one more comment. Please.
I'm not sure how well I can articulate my question, but I'm working for an organisation called the Equal Rights Trust, which works in a number of countries around the world, focusing on the rights to equality and non-discrimination. So in every environment we go into, that's our starting point. And increasingly, I'm concerned, and why I'm here this weekend, is that I don't know enough about the rights of Indigenous peoples, which have largely grown up from a different perspective, arguably. And so I suppose what I'm interested in is your views on the extent to, or on how the rights to equality and non-discrimination should be applied specifically to Indigenous peoples, and or what we need to bear in mind when we're coming from that perspective with regard to the broader context of the rights of Indigenous peoples.
Tough question.
Can I just because that is we could spend hours on that question, but there is my immediate reaction is, actually, a lot of these communities don't want equal treatment. Yeah. They want something more than equal treatment, because equal treatment would not be enough. My connection to the land of London is not the same as the connection of some of these communities to the land that they occupy. And so equal treatment may actually undermine some of the protections that are reflected in the 1989 convention. And I think that issue has been subject to a lot of academic writing. And you may want to have a look at some of that academic writing. It's a huge, huge issue. You're quite right to raise that.
Final question, quickly.
Basically, you said that you were arguing this case based on violations of Indigenous people rights, and I was wondering what will happen if you try to argue that case on environmental contamination. We did. Sorry, I did not make that sufficiently clear. We argued it on 4 grounds: violation of sovereignty, violation of human rights, violation of the harm to the environment, and violation of Indigenous people's rights. They might have similar problems, but they don't have Indigenous people as well. So I was just wondering how
Yes, if you were to have the same facts occurring on the border between France and Switzerland, it would be argued on the first 3 grounds, but it would not be argued on the basis of Indigenous people's rights. So it was the particularity of this location and the facts of this location that meant that you could run those arguments. They, in the end, occupied a very central place in the case. They went from being on the periphery to very central, and I'm very proud that happened. And I regret that we didn't get our day in court, but I understand why.
Well, Philippe, this is really terrific, really interesting and compelling, and much appreciate you making the effort to be here on Saturday morning after your long trip. Let's have a nice round of applause. Thank you.